My name is Jessica Saxon. I'm a civil rights advocate and litigator from Washington, D.C. I need to provide notice to Mecklenburg County Commissioners this evening. This is in accordance with USCS Rules of Civil Procedure, as well as Rule 17 and Rule 20 of the United States Supreme Court. The Constitution for the United States is the overarching requirements that every state must follow. I trust that everyone here would agree with that. States are not able to enact their own alternative legislation and substitute it for the guarantees of the Constitution. That would mean that your state laws are, in fact, more powerful than the Constitution, and that is unlawful. Clause 1 of Amendment 5 to the United States Constitution says that no person should be held to answer for a capital or otherwise infamous crime unless on presentment or indictment by a grand jury. However, the state of North Carolina has enacted its own alternative legislation that permits prosecuting attorneys and police officers to charge by way of information as opposed to indictment as required by law, and that is unconstitutional. An emolument violation is when you pay a public official to commit a crime. There are two areas in the Constitution that reinforces this. The first is Article 1, Section 10, where it states that no state shall create any law that shall impair the obligation of contract. So contracts, police officers, prosecutors, judges, they are all under a contract to perform based on the oath or affirmation that they took. The contract perimeters are defined within the Constitution of the United States. So when a state enacts a law that directs their agents to disobey the supreme law of this land, that would be a violation of Article 1, Section 10. The 14th Amendment is the other place that you'll find the reinforcement of this issue, and that's where it states that no state shall create or enforce any law that shall abridge the privileges and immunities of United States citizens. Privileges and immunities of United States citizens are at a minimum those that are enumerated within the Bill of Rights and the First 10 Amendment. The state of North Carolina has enacted a law, again, in its inferior constitution that is permitting public officials and law enforcement officers, whom you all pay, to violate the Constitution of the United States. As a result, there's an inordinate amount of people currently imprisoned here in the state of North Carolina illegally and unconstitutionally. Mr. Tannenwood Downing is preparing to litigate this issue at the United States Supreme Court on behalf of more than 700,000 people currently imprisoned here in America unlawfully. I'm here today to simply provide notice that you cannot continue to pay public officials to break the law. Criminal sanctions can come from that. Paying public officials to disobey the law, it is an emolument violation, it is illegal, it is unconstitutional, and it is a crime. So please let the record show. I'm asking you, honorable individuals, go home tonight, take a look at Clause 1, Amendment 5, confirm what I'm saying to be true, and direct your public officials to act in a lawful constitutional manner consistent with the obligations that are codified in the Constitution of the United States of America. And I do have a notice that I would like to put on the record. Thank you so much.
Thank you. Tanel Downing, you have 3 minutes.
So good evening. My name is Tannenwood Downing. I'm the civil rights litigator that Ms. Saxon was just talking about. I want to provide a little bit of clarification so we can understand what just happened. I have approximately 34,000 criminal affidavits on behalf of affected victims that have had this happen to them from right here within the state of North Carolina. Many of them are from within the county of Mecklenburg. These are per se crimes, which means that we don't have to prove that they intended to breach their constitutional obligation. Simply by virtue of the breach, all elements of the crime have been met, because their willfulness and their knowledge derives from the promise that they make. No state can create its own alternative legislation, substitute it for the guarantees of the Constitution, then go out and enforce it as though it's law. That is unconstitutional. So if your sheriff's department, your agents that you pay, if they're going out and executing a warrant because they're relying upon a judicial officer who relied upon a prosecutor who abused their power by relying upon an inferior state statute to deprive a person of a right that they're guaranteed by the Constitution of the United States, your sheriffs are now performing an unconstitutional arrest. And when they take that individual and put them into a jail, that jail is now acting unlawfully and unconstitutionally because it derives from an unconstitutional arrest. Now there's a crime, Title 18, subsection 242. It's deprivation of rights under color of law. What that statute says is that any person who, under the color of any state statute, ordinance, custom, or regulation, deprives any person of any rights secured by the Constitution commits that crime. There's a second crime called conspiracy to deprive rights, Title 18, subsection 241. What that states is that when two or more persons conspire for the purpose of depriving any person of any rights secured by the Constitution commits that crime. Now, the law of criminal conspiracy with regard to public officials states that any person who, having knowledge of any of the wrongs conspired to be done and who have the power to prevent or aid in the prevention of a commission of same, neglects or refuses to do so, may be joined in dispensing the action. So upon having been provided this notice that you are paying the sheriff's department to act unconstitutionally and that you're paying for a jail to house people unconstitutionally, I would ask you guys to please, let's stop, discontinue those unconstitutional acts, and let's direct them to act in lawful manner. Now, I'm not saying that these people are good people. I'm not saying that they're lawful people, but I am saying that they're rightful people and their rights have clearly been abridged by the state of North Carolina by agents of yours. So let me be clear. I'm not trying to change the law. Rather, I'm pointing out what the law states and that the way in which it's being enforced directly contradicts with what is specified. Therefore, I'm not trying to change the law. Rather, I'm asking that we uphold the law. If the law states that something will be done in a certain way, then we must follow that way. Laws do not change arbitrarily. That is tyranny. Constitutionalism demands that the laws evolve only through suffrage. Therefore, it's up to the people to decide whether or not the Constitution applies to them and not a judge or a state. So I know that you're going to go and you're going to ask your city attorney right after we're done if this is true, if what he's saying is real. And before you choose to rely upon their advice, just understand that they're going to point you to a Supreme Court case from 1884 called Hurtado versus California. The Supreme Court of the United States has no constituted authority to alter, amend, or destroy the Constitution of the United States. The Constitution is the foundation, not a judgment ruling. God bless. Thank you guys so much.
Thank you very much.
We the people on this ground we stand, with hearts wide open and courage in hand. The winds of change, they howl and they plead. Let the chains fall, brother, let us be free. We shall be free like the stars up high. No man can cage the truth we can't deny. Through the storm, through the night we'll see. We rise together, we shall be free.